Hello, my name is Joseph Tully, and I am the founder of Tully and Weiss Attorneys at Law, and we are a criminal defense firm based out of California. We do mainly state court cases, but I have done federal cases, including federal cannabis cases. And I want to thank everyone for their time today. And I'm going to be speaking from that perspective, that of a criminal defense attorney. I think, though, it applies to everyone for the reason that the Constitution still has teeth. So you can make logical arguments, you could talk to legislators, but really a point of attack that I'm not seeing enough people take advantage of is in the criminal court system. Meaning anyone who is facing charges, federal charges, anything related to cannabis should be making these arguments that I'm about to give you. My firm has taken some arguments that have been done before, but we've added our own sort of twist to them. We've updated them, and I feel very passionately about this issue. And I do think that if everyone in the whole country who is facing criminal charges having to do with cannabis files this motion, at some point we are going to win. And even if it's not winning in the criminal court system, it will make its way to the legislature. In other words, if we are attacking the federal scheduling of cannabis in the criminal court system, let's say judge after judge after judge starts saying, look, I'm not going to change it. That has to be done with the legislature. Eventually, that will put pressure on the legislature. But that's a backup plan. That's plan B. Plan A is quick, simple, concise, and surgical, and it can be done. It can happen next week. We could have the federal scheduling as it applies to cannabis thrown out next week by a judge. I'm going to walk through the arguments, but another thing to know that I want everyone to know, I don't have any problem sharing our work. So the motion that we've developed, I would freely send out to any attorney, any pro per litigant, anybody who has interest. Just contact me or my firm, and we will send out this motion to you. The more people taking this motion to court in federal court and your state courts too, because it can be argued in state court. That adds another layer to the argument, but it is very possible. So, without any further ado, let me start going through the specific arguments. Um, so the argument that should be made for people facing cannabis charges in federal court are that the charges violate Equal Protection Clause, the 14th Amendment, and they also violate the Due Process Clause, so the Fifth Amendment. Um, so equal protection, we've all heard that phrase, but it basically boils down to similarly situated individuals must be treated the same under the law. And whenever you have an equal protection issue, one of the tests that the court applies is the rational basis test. So, in other words, if there's a federal law, we'll just take a very basic examples. If there's a federal law that treats people differently, there's one of three tests that are invoked. One is the rational basis test, one is intermediate scrutiny, and one is strict scrutiny. So if there was a law that was passed that discriminated against people based upon race or immutable characteristics, which is characteristics about yourself that you can't change, how tall you are, what race, um, just different characteristics, then that would be strict scrutiny. Um, for some things traditionally in the past that have involved discrimination based upon gender, it was intermediate scrutiny. However, at the most base level, the most basic foundation, all laws where it discriminates against similarly situated people are that it has to be It has to have a rational basis. Okay, so if you were to grow your own oregano and make, essential oils based on that, it has excellent homeopathic properties. It has excellent healing properties. You wouldn't be prosecuted federally. However, if you grow cannabis and want to make essential oil from cannabis or any other natural, homemade, homeopathic remedy using cannabis, you could be prosecuted federally. So there we have two people doing the same thing that are being discriminated against by our federal law. One person, nothing happens to them because they're using oregano to make essential oils or to make homeopathic remedies. Another person using cannabis could be prosecuted and could be facing prison time. So you would have discrimination. So that's our jurisdictional hook to get to the rational basis test is that we have to argue a violation of the Equal Protection Clause. Now that we've argued equal protection and we've established that there are similarly situated individuals being treated differently under the law, we get to apply the rational basis standard. Um, and and along with these same arguments, I'm going to go through the elements and how it would be argued in court. But that's essentially the introduction for the equal protection argument. Going along with that is a due process argument. It's very, very similar, but you would want to argue every constitutional violation that you can in court. You don't pull your punches. The government doesn't pull punches when it's prosecuting people. You don't want to leave any arguments on the table. So for the due process argument, you're basically arguing that the federal schedule um, doesn't follow, it's very similar to rational basis, that it's vague and confusing and therefore unconstitutional. So equal protection argument boils down to rational basis. The due process argument boils down to vagueness and overbroad and using confusing terms. And we'll get to why the federal schedule violates that as well. And it's basically the same argument as you would use for equal protection. But again, two different legal theories that you want to argue, equal protection and due process. So because someone is facing injury in court, being convicted of a federal offense, and the crime, the prosecution boils down to the federal schedule. And as everyone knows that's listening to this, cannabis is a Schedule One, is classified as a Schedule One drug. Um, Now, courts do have jurisdiction. There's case precedent. It will be uncontested that courts can hear argument on the federal scheduling. Um, so, so now we're going to walk through the intricacies of the legal argument. And we're going to pick out some of the statutory criteria regarding Schedule One and argue how and show how and prove how it does not apply to cannabis. Number one, high potential for abuse. Number two, no currently accepted medical use. Number three, lack of accepted safety under medical supervision. And we can prove in court, it's been established, this is not anything new. That all of that cannabis, that should not apply to cannabis and therefore cannabis should not be classified as a Schedule One drug. So we have widespread medical acceptance of the use of cannabis. We have legalized medicinal use in 47 states. Now, in addition to the 47 states, we have medical use in Washington, D.C. Now, there was this litigation was done in Sacramento many years ago. Ultimately, at the end, the judge refused to act, saying that, well, Congress can still act and make a decision. Um, Here's why this motion has to be brought again in court right now. Because Washington, D.C. is not a state. It is controlled by Congress. In Washington, D.C., allowing medical use, Congress has explicitly recognized the medical value of cannabis. So it can no longer be said that there's no acceptable medical use. We know that as a fallacy. We know that does not apply to cannabis. We have FDA approval of Delta 9 THC-based medications. So FDA, Federal Drug Administration. We have the federal government recognizing that there is medical uses of Delta 9 THC. So with those two things right there, Congress explicitly approving medical use in DC, the FDA, which is a federal agency, explicitly approving Delta 9 THC based medications, we know right there that there is acceptable medical use for cannabis. And that is obvious. It's been obvious for many, many years, if not many, many decades. So uh, judges, federal judges, should not be dragging their feet. They do this all the time. Federal judges will strike down a law if it is unconstitutional. So why aren't they doing it with regard to cannabis? It's because it's a political hot potato. But whether or not something is politically favorable or not should not apply in a constitutional argument. We need to follow the law. We need to follow the Constitution. I believe it was John Adams, who was our second president, who said that we need to be a nation of laws, not of men. And in the vernacular of the time, what that meant is we need to let the law be our guide, not passion, not prejudice, not personality, not ego. And if we all look at the Constitution and let that be our operating system, then we will arrive at the right conclusions. We will have a just society. We will have a merciful society. We will have an orderly society. And we will have a compassionate society because our Constitution will be our guide. So again, if there is any one of the criteria in Schedule 1 that does not apply, then Schedule 1 does not apply. It's sort of like a chair. Imagine a chair has four legs, and if you were to take one of the legs away from a chair and sit down on it, what would happen? You would fall down. That chair would no longer be functional. So, since this prong now has been, we could show in court that there is an acceptable medical use for cannabis, then the Schedule 1 does not apply to cannabis. Any federal judge who hears this um, should instantly rule federal schedule does not apply as to cannabis, or at least Schedule 1 does not apply to cannabis. And that's really their proper function. They shouldn't say, well, it's not Schedule 1, it's Schedule 2. Oh, it's not Schedule 1, it should be Schedule 3. It should be, number 4. That part is not up to the judge. A judge should just say, Schedule 1 doesn't apply. Congress, your move. The ball is in your court. You fix this now. So let me go back to my notes. So we've shown, and anybody would be able to argue in court that there is currently accepted medical use. Um, we could also prove, through many, many studies, there is not a high potential for abuse. Cannabis is there is some abuse. Some people may disagree with me on that, but there are people who get psychologically addicted. There's good and bad to everything. However, the high potential for abuse really is non-existent. That is not a good argument. I believe that even that prong will not hold up in court if a judge does the right thing and allows argument to happen. So again, so that there's acceptable medical uses and there is acceptable safety under medical supervision. All of that can be proved in court. So since we can prove that the criteria necessary for something to be a Schedule One substance doesn't apply, that means it would fail the rational basis test. And again, as Americans living under the Constitution, and we all live under the Constitution, um, we need to we shouldn't, we know that we are not forced and we should never be forced to live under irrational government laws. It's not our problem, it's the government's problem. It's not our problem to fix. This is a law, it doesn't work, it's not rational, and a federal judge, should rule favorably as it applies to cannabis on this issue.